Hi, my name is Ruben, anak lelaki Kumaran, number matrix S60574. I am from Group 24 and we consist of 3 members. Another 2 members are Muhammad Aiman bin Norman and Muhammad Faris bin Razali. We would like to present about question 11. So question 11 is about Tan Sendirian Berhad manufacture various kinds of electrical goods for household purposes. After looking at the sample of an electrical stove, Munir, a retailer, ordered 50 stoves from the company. When Munir received the goods, all of them corresponded with the sample. One of the stoves was sold to Bibi. When Bibi first used the stove, it exploded, which caused a fire breakout in Bibi's kitchen. The kitchen was badly damaged, and Bibi and her child suffered from severe burn. So we have to advise Bibi on her rights against Munir and Tan Sendirian Berhad, and also discuss whether Munir can bring action against Tan Sendirian Berhad or not. So firstly, we start on advise Bibi on her rights against Munir and Tan Sendirian Berhad. So the issue here is Bibi has the rights against Munir in respect of guarantees in the supply of goods. So for the principle, we will look at Section 41(2) Consumer Protection Act 1999. In the event that any goods fails to meet a guarantee, the customer has a right of recourse against the supplier. The consumer has the right to seek damages from the supplier for any loss or damage he or she has suffered, other than loss or damage caused by a reduction in the value of goods that is proven to be a result or consequences of the failure. Case to support about this issue is from Priest versus Last on 1903. This case demonstrates the principle that if the buyer informs the seller of the specific purpose for which the goods are being purchased, it is an implied condition that the goods are suitable for the purpose. The buyer of a hot water bottle from the seller in this case was a chemist. His wife used the hot water bottle 5 times before the bottle burst and scalded her. The bottle was not fit for use as a hot water bottle according to the evidence. The buyer claimed that the implied condition of fitness for purpose had been violated. The buyer had not specified the purpose for which the hot water bottle would be used. According to the seller, the court, however, dismissed this claim. The seller has a right to recover the cost of treating the buyer's wife injuries according to the code, because the buyer trusted the seller's judgment and the seller had indeed used the hot water bottle for its intended purposes. In this case, we will assume that Bibi purchased the stove from Munir based on Munir's description. As a result, under Section 41(2), Bibi, as a consumer, has the right to require Munir to remedy the failure within a reasonable time, or to seek damages from Munir for any reduction in the value of the stove below the price paid or payable by Bibi for the stove. Bibi also can claim Munir for damages for the loss or damage that occurred in Bibi's kitchen, as well as the injury to her child who suffered a severe burn as a result of the failure.
Hi, my name is Muhammad Aiman bin Rahman. Right now, I will continue the presentation for the right against Tan Sendirian Berhad. The issue that come out from this problem is, did Bibi has the right against Tan Sendirian Berhad in respect of guarantees in the supply of goods? Okay. For the principle is Consumer Protection Act 1999, Section 50. The good do not meet the implied guarantee of acceptable quality set forth in Section 32 because the good do not correspond to a material description applied to the goods by or on behalf of the manufacturer, or with the express or implied consent of the manufacturer. The good do not comply with the implied guarantee of correspondence with description under Section 34. The application is, Munir sold the stove after confirming that it was identical to the sample. Unfortunately, the first time Bibi used the stove, it exploded, causing a fire in the kitchen and served burn to her child. there was a violation of the implied condition of ad description of acceptable quality. As a result, BB has the right to sue Tan Sri Berhad under Section 50 of the Consumer Protection Act. Another issue is, can Munir bring action against Tan Sri Berhad for breach of Act? Principle, according to Section 17.2, Sale by Sample, Sale of Good 1957, a contract for sale by sample is one in which there is an express or implied term to the effect in the contract. There is an implied condition in a contract for sale by sample. First, that the product shall correspond with the sample in quality, and second, the buyer shall have a reasonable opportunity of comparing the product with the sample. So, another case to support this issue is a case between Drummond vs. Veningen, 1887, which is about a manufacturing company that submitted a material sample to clothes merchants placed an order for a quantity of material of the same weight and a quality as the sample. The tailor later discovered that the clothes that was then tailored into garment did not suit the purpose for which it was intended, despite the fact that it was equal to the sample. While the clothes were equal to the sample, the court held that this did not protect the manufacturer because the defect could not have been detected by a reasonable examination. As a result, the buyer was not obligated to accept the material. So the application is, Munir, a retailer, has placed an order which Tan Sri Berhad for 50 stove. Munir examined an electrical stove sample before purchasing the 50th stove. When Munir received the goods, however, they all matched with the sample. Munir customer, BB, had suffered damage and served burn when she first used the stove. Despite Munir's thorough examination, the flaw was not visible on such a thorough examination. As a result, Munir has the authority to take action against Tan Sri Berhad for breach of the condition of sale by sample under Section 35 of the Sale of Goods Act.
Okay, in the conclusion, we can conclude that if goods fail to meet a guarantee, the consumer has a right of recourse against the supplier and also has the right to seek damages from the supplier for any loss or damage they suffered. Besides that, a retailer has the authority to take action against the supplier if breach of the condition of sale by sample under Section 35 of the Sale of Goods Act, that the product shall correspond with the sample in quality and the buyer shall have reasonable opportunity of comparing the product with the sample. Okay, that's all from us. Thank you.